Hello everyone, and you're all very welcome to today's webinar on building a reputation for ESG. Today's webinar is part of our Client Experience Programme webinar. So I want to say a big welcome back. Lots of you have joined us for many of these sessions over the last number of months. It's also a first webinar in a series of webinars we're doing over the coming months on ESG. So equally, if it's the first time you're joining us today, you're also very, very welcome. Irrespective of how you've joined us, the focus for us is always the same when it comes to these sessions. And that's on bringing you practical insights on the issues that matter most to you and your in-house legal team. With corporate greenwashing continuing to dominate international media headlines, that's very much the focus of our session today. The next hour is all about you. We'd love you to engage as we move through today and to really get the most of the session. If questions occur as we move through the content, pop them in the chat, or of course, you're always welcome to come off mute and ask us. We will be doing a discussion session at the end. With that in mind, we're going to start, as we often do, by getting your view on this particular topic. So what we'd love to know today is, what are you most concerned about from a litigation risk perspective when it comes to this area? So maybe it's regulators, either from a stock market or an advertising perspective. Maybe it's your consumers, class action in particular. Maybe it's NGOs taking action. Perhaps it's your competitors and you're thinking about them driving some of this activity. Maybe it's investors or financiers, or maybe it's something else. Now, if it is the case that it's something that's not on that list, pop it in the chat. We'd love to hear your view on this. Okay, so great to see lots of people already getting involved and getting engaged in this topic. We will give a few more seconds for anyone who'd still like to indicate a preference. So let's do a 5, 4, 3, 2, 1. Excellent. It's still moving up, so I'm gonna hold on 2 or 3 more minutes for any last minute votes. Excellent. Okay, so let's end the poll and share the results with everybody. And with that in mind, I'm very excited to introduce you to my colleague, James Langley. James, I know you're dying, I can see you, to comment on the results here. So I'll hand you over to James, everyone, who will take you through today's session.
Thank you, Niamh. And I would say that these results, we've got regulators at 45%, consumers, class actions at nearly 20%, and investors at 20%. I would say that chimes very nicely with what we're going to talk about during this session, and the focus that we're going to have on the regulatory position, but also the risks in terms of class action and other kind of claims that will come through. So that's a really interesting opening poll. I would like to start with some introductions. So I'm James Langley. I'm a partner in Denton's dispute resolution team based here in London. And with me on the panel this afternoon to discuss building a reputation for ESG without greenwashing, I'm very pleased to introduce Michael Duval, a partner in Denton's Los Angeles office. Michael defends companies in consumer class actions, so it's going to be a particular focus on that, complex litigation and related regulatory actions. He's defended more than 100 class actions at all levels, including successfully trying a class action. I've just lost my screen. Securing judicial approval of complex settlements, arguing appeals in federal and state appellate courts throughout the country, and litigating class action questions in the US Supreme Court. And absolutely on point, he's also a member of Denton's Global ESG Advisory Board. We also have Annabelle Hodge. Annabelle is a senior associate in the Environment and Safety team at Denton's, based in London. She has experience in both contentious and non-contentious environmental and health and safety law, and has worked on a broad range of regulatory compliance issues. She advises clients in various sectors, including waste, chemicals, oil and gas, retail, clean tech, mining, construction, and transport. And finally, Jennifer Wormsley, a partner at Denton's Global Advisors based in the London office. And she specializes in advising companies and investors on managing the increasingly complex area of ESG strategy and communications. She's got nearly 20 years of experience of working at board level with some of the largest companies on issues including climate change and human rights. So in terms of today's agenda, I'm going to turn over shortly to Jennifer, who's going to speak to some recent high-profile media headlines. I'm then going to speak briefly to the regulatory landscape. We're then going to turn over to Michael to understand some more about the learnings from recent cases. Annabelle is then going to deal with response strategies for in-house legal teams. We'll then go back to Jennifer for a key area, I think, which is communications and crisis management. And we will finish, hopefully we will have some time for questions from me to the panel on horizon scanning and related advice for in-house teams. So without further ado, I'm going to turn over to Jennifer to tell us about some recent high-profile media headlines.
Great, thanks James for setting the scene, and good afternoon, good morning everybody. Now we know that companies today are feeling the pressure from multiple stakeholders to show their ESG credentials. So perhaps it's unsurprising then that this has resulted in some becoming over enthusiastic in their claims. I've picked out a few of the many examples from the last year or so where the media has pounced upon ESG missteps or overstatements and covered those in depth. As many of you will know, this is Earth Month, and one of the things that we've seen from our analysis, interestingly, is that references to greenwashing do actually tend to increase around world events such as Earth Day, the COPs, World Water Day. Partly this is because there's heightened scrutiny of sustainability related issues and credentials at that time, but also it's because companies often choose to time announcements of things like new commitments to coincide with these types of events. So I think that's an interesting observation from what we've seen. So when we're talking about greenwashing, what do we really mean? Well, we're talking about businesses making claims that are either partially true, claims that might be true but can't be backed up, or in some cases, claims that are entirely fabricated with no real intention to deliver on promises at all. And there are a variety of different ways in which we see this coming through. Sometimes it's organizations using slightly sneaky or vague language. Sometimes it involves being selective about what you talk about, so focusing on a particular aspect of a product and ignoring the less sustainable aspects of it. And sometimes we see it through companies ignoring the bigger picture. So, focusing again on one thing, but, not really not covering the full story. So cherry picking what it is that they're focusing on. And the media focus that we see coming through on this slide is, of course, reflective of the focus across many different stakeholder groups. And we saw in the poll a few moments ago that, you're worried about accusations coming from employees, from consumers, from NGOs, activists, investors, which interestingly came out more strongly this afternoon than it did when we spoke to the Australasia audience this morning. And finally, regulators. That was the top answer again this morning, which showed that a lot of you are most concerned about risk coming from regulatory pressure and regulators calling out greenwashing. So now I'm going to hand back to James, who's going to cover that particular stakeholder in more detail.
Thank you, Jennifer. So it's an obvious point, but regulators everywhere are focused particularly on greenwashing right now, and they're becoming increasingly interventionist, but also the regulatory landscape is changing quickly to reflect a more sophisticated understanding of how green credentials can be substantiated. And it's only going to become more demanding for businesses going forward. This afternoon, I'm going to speak to two relatively recent instruments. First, the UK Green Claims Code, and then the EU's proposed Green Claims Directive. Now, not everyone on the call is going to be focused on the UK and the EU markets, I appreciate, but I think what's important about these is the practical guidance that they contain, and I think they have that has global relevance. So focusing first on the Green Claims Code, this is a guide published by the UK Competition and Markets Authority in September 2021. It's aimed at protecting consumers, but also businesses who are really making accurate environmental claims, but experiencing unfair competition from those who aren't. And there are 6 principles, and I think these are really, as I say, of universal application. Firstly, claims must be truthful and accurate. So a classic example would be claiming that a product is recyclable or organic if it's not, or if only parts of it are. And the point is made in the code and the related guidance, which is worth reading, that more general or absolute claims like green or sustainable or eco-friendly are more likely to be inaccurate and potentially to mislead. And so you need to be wary around those. And also that this doesn't just apply to names, it can be logos, labels, symbols. Secondly, that claims must be clear and unambiguous. So if we're talking about claims about future goals, they should only be made if a business has a clear and verifiable strategy to deliver them. And claims shouldn't just focus on positive environmental aspects if a product has other aspects which are negative. Claims must not omit or hide important information, and we're going to talk some more about this, but offsets in particular need to be properly explained, including the scheme that's been used. And if information would make consumers think twice about buying a product, they say in the guidance, of course, that's a strong indicator that the information should be included. Comparisons must be fair and meaningful. I'm going to talk a bit more about that in a moment. Claims must consider the full life cycle of the product or the service. And I think really importantly, claims must be substantiated and the evidence must be robust, credible and up to date, whether it's published research or studies that a business has conducted. Now, I would say the Green Claims Code was quite pioneering, and I think it's had a lot of traction. I think it's beginning to look a little simplistic now, and we're seeing more specific legislation coming through. And I think the EU Green Claims Directive will be an example of that. It's currently just in proposal form, and it's part of the regulatory framework for the European Green Deal. It applies to products on the EU market and the claims of traders that provide activities on the EU market, but the businesses could well be non-EU, and so it does have broader application. And it addresses the substantiation and communication of environmental claims. Now, it may be worth just giving some context to this. There was a 2020 study that was undertaken within the EU that found that 53% of environmental claims provide vague, misleading, or unfounded information about a product's environmental characteristics. So that is why the EU has, I think, a correct perception that consumer trust in environmental claims is relatively low, and this kind of legislation is needed. I'm not going to go into detail, but again, I think there's some really practical things that come out of this proposed directive. Firstly, traders must carry out an assessment to substantiate explicit environmental claims. So again, this is similar to what we've seen with the Green Claims Code, ensuring that they're relying on scientific evidence, making sure that they're not being selective in terms of talking about only part of a product, looking at the impact across the life cycle. And then there's an article around the comparative claims. It's really important that if a product or a business is being compared to another product or business, equivalent information is being used, including equivalent data and assumptions, and also looking at equivalent stages of the value chain and equivalent environmental impacts. And I think that's going to be key. And then there's a really interesting article around the communication of environmental claims and the importance of doing that, of course, in accordance with the directive. But also, you may be saying, you may need to say how consumers can use products to decrease the environmental impacts. And of course, you need substantiating information, underlying studies, etc. I think one of the really important things that's going to come out of this directive when, and I'm sure it is when it becomes law, is that companies will need to obtain a certificate of conformity from an independent accredited third-party verifier before making the environmental claim. So we're going to see a whole industry built around verifiers, and there's going to need to be that before you can even make the claim. And claims that don't meet those criteria will have to be removed. Inevitably, there's going to be a cost to business in all of this, and there's going to be a question around whether or not it is worth going through that process in order to make the environmental claim. And finally, the EU Green Claims Directive, like the Green Claims Code, has quite a bit to say about offsets. I think this is a really tricky area right now. The offsets have to be reported separately. It has to be clear whether they relate to emission reductions or removals, and the only offsets that can be used are those of high integrity and which have been accounted for correctly. And as we know, that isn't an easy thing to achieve necessarily. So I think there's some really interesting material in those instruments, and we're going to see a lot more regulation coming forward, and as I say, a lot more intervention from regulators across the globe. And with that, I'm going to turn over to Michael, who's going to tell us some learnings from recent cases that he's been working on.
Thank you very much, James. And again, thank you everybody for joining us today. So over here in the United States, where are we seeing the most activity in terms of ESG, greenwashing, litigation, and related claims? To take a step back, in the US, the primary regulators surrounding these types of claims that are made on consumer products tend to be the Federal Trade Commission, or FTC, relating to advertising, the FDA to the extent food or cosmetics products are involved, the Environmental Protection Agency, EPA, over all things environment, and with respect to securities, the Securities and Exchange Commission, the SEC. For the most part in the US, with respect to consumer-facing products and goods, the plaintiff's class action bar fills in much of the enforcement activity. FDA and even FTC, to a certain extent, are not necessarily on the forefront of advanced enforcement action, although I say that last week the FTC sent out, I believe, 700 warning letters to companies about claims that will be encompassed in our presentation. But again, in the US, we're mostly talking about, and as your poll results confirmed, the risk of consumer class action enforcement by the private plaintiffs' bar. So where do we see most of that here in the US? Well, we see it in my home state of California. We see it here where I'm physically presenting from, the state of New York. And we also see a lot of this activity in the state of Illinois. Over the past several months, dozens, if not hundreds, of class actions concerning ESG, alleged greenwashing claims have been filed in just these 3 states over the past several years. Hundreds, if not thousands, of these class actions. So what types of claims are the targets of these sorts of class actions? I tried to break them down on this slide as just your basic punch list of alleged greenwashing claims. And I'd like to just briefly focus your attention on the second bullet on this list. I think everyone is familiar with litigation around terms like natural or organic. That's actually nothing new. The plaintiff's bar has been targeting those sort of claims for many, many years. But now we even see a second, third, or fourth generation of legal claims concerning statements like naturally derived or made with natural ingredients. So in other words, it's not enough to move on from the target of the plaintiff's bar to not say all natural or 100% natural. If you have buzzwords like this on your products, chances are the plaintiff's lawyers are going to be looking for a way to sue you and accuse your company of greenwashing. Similarly, with respect to claims about what is not in your products, whether it's preservatives or synthetics or artificial ingredients or chemicals, an earlier slide noted the headlines around PFAS, PFAS, and whether products contain trace amounts of those chemicals. Actually, our firm has a webinar solely on PFAS, I believe, tomorrow, so tune into that. And oftentimes those types of claims, those types of legal claims are brought under the guise of what I've put under item 4 on this slide, which is statements on your products or goods about the product being clean or pure or safe or gentle. More broad terms that don't make a specific representation about the presence or absence of a particular ingredient, But according to the plaintiff's bar, by making a statement that the product is clean or safe or pure, it has an implication that it is free of allegedly harmful ingredients or free of allegedly harmful chemicals. So we see a lot of litigation around that. And then, of course, around terms that were flagged earlier, whether the product is recyclable or made from recycled materials, and even if the product just has what we'll call green imagery. If the package is green, if there's a green leaf on it, you see class actions even alleging that that can be misleading, greenwashing types of claims. Which then brings me to our even broader type of class action claim that we're seeing. And we've seen a lot of these cases this year. These are cases alleging that a company has carved out a reputation of being green or eco-friendly, and then that reputation permeates its entire business, whether it's selling a food product or a cosmetic product or any other consumer product, that it has put out there in the world that it is a green and eco-friendly company, whether through ESG statements made to its investors, and has cultivated a reputation which the plaintiff's bar alleges is false and misleading, and in turn drives consumers to rely on that reputation in purchasing a particular product. And if the company is not actually ESG friendly, is not eco-friendly, then those purchases have been made in reliance on a false representation. You see that with respect to claims around a company using sustainable practices, such as farming practices, ethically sourcing its labor from around the world, or just being generally eco-friendly. So we're seeing a lot of those too. Now, to take a half a step back, what drives all of this litigation, particularly here in the US, particularly consumer class action litigation? And it's really just three pegs of the stool: trends, money, and paths of least resistance. We've talked about trends, and if we're just going to put ESG claims under the very broad heading of a trend, plaintiffs' lawyers are going to follow what consumers are responding to, what businesses are focusing on. Money, obviously, plaintiffs' lawyers, particularly here in the US, will follow the money. And if you'll go to the next slide, I looked up the statistics on the consumer class action industry in the US. So the class actions are, according to a recent study, a $4 billion industry here in the United States, with consumer class actions constituting approximately a third of that. Frankly, in my experience, I think these numbers are low. I have some cases that I would think have a pretty good share of that number, and I know there's a lot of cases out there. But point is that this is big business here in the U.S. So next slide, please. Back to where we are focused on in terms of the litigation hotspots: California, Illinois, here in New York. You combine the large consumer bases of each of those states. California is the 5th largest economy in the world. New York is the 12th largest economy in the world. You add that with, generally speaking, consumer-friendly laws in those states. In the US, a lot of this litigation is resolved by state laws around deceptive business practices, around false and misleading advertising. You put those factors together, and you have a litigation hotspot, particularly for this consumer class action litigation. Now, I mentioned a few slides ago that there's a third part to this equation, which is paths of least resistance. So again, we see in my class action world, plaintiffs, lawyers will tend to follow the easiest course to get their case positioned for trial, and therefore to have it leveraged for a class action settlement. And with respect to the companies, the industries that are targeted for alleged greenwashing, again, these tend to be food, beverage, nutrition supplement, cosmetic, beauty products, personal care products. Those sort of companies making those sort of consumer goods with those sorts of claims are going to be targeted with those cases. Where do consumers buy those products? They tend to buy them still on the shelves in grocery stores or in other retailers. And what does that mean? Well, here in the US, our US Supreme Court has actually, over the past 10 or 15 years, given us as class action defendants a lot of tools to reduce class action litigation, one of which is the enforcement of arbitration agreements with individual arbitration required, meaning no class actions. Those are often found in online terms of use. Well, what do you not do when you buy a product in a grocery store or at a Walmart or at a Costco? You don't necessarily sign up for an arbitration agreement at the point of purchase. Now, I know you're all saying, hey, everybody buys everything online nowadays. I'll revisit that in just a few seconds. But point is that these particular types of products tend to be ones that don't necessarily have that silver bullet right at the outset of a case of an arbitration agreement. Now there is, and this is a subject for a whole different presentation, but there is a trend of mass arbitration demands. And if you're listening to this presentation and you don't know what I'm talking about, we need to talk offline about that tactic of the plaintiff's bar. The other path of least resistance point here and why we see all this consumer litigation around these greenwashing claims, the jurisprudence in this area, meaning the case law just isn't that developed relative to other areas where we've had class actions denied certification over and over, where we've had some tried that we've won, where we've got case law up to the US Courts of Appeal and up to the US Supreme Court. It's still relatively nascent in terms of just the case law that's developed. And what that means is that the companies have yet to really disincentivize the plaintiff's bar from pursuing them. As we see in other industries, until a number of business side wins are stacked up and the plaintiffs know that they're not going to be able to bring a case and win it quickly or get a settlement quickly and get paid quickly, they're going to keep bringing them. Next slide, please. What have we learned from the cases that have gone, not necessarily to trial? I've tried class actions, but not in this space, and there's only a few that have gone this far, but they will. But what have we learned from cases that have at least gone fairly far in this area? Much to the surprise, oftentimes, of our our clients' marketing departments, sometimes the claims that are made on these packages or on these labels don't quite matter to consumers as much as the marketing department thinks. Another very much related point is that the claim, the alleged greenwashing claim, does not necessarily mean the same thing to, let alone all consumers, even a majority of consumers. And that can be very important in terms of how we are able to defend a case when we're talking about issues of causation or materiality or reliance. Another key point that comes out of the cases I mentioned, regulators, FDA, FTC, even EPA, while they haven't defined many of these claims, they have defined some. And I tend to like to be in a position in defending a case of being able to point to my client's compliance with an applicable regulatory definition or even regulatory guidance on what a claim means in terms of being able to defend it against what a plaintiff's lawyer is alleging it should mean or does mean to reasonable consumers. Which then brings me to the last slide here. What can you as in-house counsel do in order to prevent these types of cases or at least mitigate their risk? Because after listening to me for the past few minutes, you're probably thinking, why bother with all these ESG claims, particularly on consumer products? First, and take a deep breath, in the US, this is a cost of doing business. It's at least a $4 billion industry, and it's state by state, and you have states with very large economies. If you're selling consumer goods in the United States and you're having any degree of success, you're going to be targeted as a consumer class action defendant. You can mitigate the risk of being sued, and you can mitigate the ultimate result of that lawsuit if you take some advanced steps. obviously review product advertising and labeling in advance. You're saying to me, we're the legal department, we're the no department, we're a cost center, our marketing team, our sales team are actually driving revenue. We're not going to have a lot of engagement on that. Get the label in advance and just mark it up. So send it to your outside counsel and let them circle words that we can tell you, this is absolutely going to put a target on your back to get sued. You can change the word and not affect your sales in any material way, but affect your litigation risk in a material way. Ask your team for substantiation for the statements. If when you ask them for that, they are Googling the answer in front of you, that's a bad sign. Ask them to give you studies and research, particularly backing up the particular claim. Update that substantiation. As a class action defendant, variation is good, current information is good. Have a process in place to update every 1 year, 6 months. And to the extent you as in-house counsel are involved, keep this privileged. I like to be in the position in defending cases of deciding how we're going to get information that's helpful out, even though it's underprivileged, rather than trying to figure out how to make information that's not helpful privileged when it wasn't. So get involved in this process in your companies early. And if you're still saying to me, Mike, that's great, but this just isn't going to happen, we're the legal department and our role is narrow, have your outside counsel come in, do a free presentation. And I do this for clients all the time. And I start with, here's what the last class action case cost to defend. Here's how that cut into your profit margin for these products. If you would have taken these 2 steps prior to launching this product or launching this ad campaign, we would have avoided most or all of this. That will get attention. That will get buy-in to these advanced proactive measures. That will make your outside counsel, not you, the bad guy in these delivering these messages. Just briefly, I mentioned I'd go back to online, the use of online terms. Make sure your terms are up to date because sometimes in these cases, frankly, you get lucky and your plaintiffs have been online and it's nice to have an enforceable arbitration agreement with a class action waiver in place. Take a look at those membership rewards programs that your companies may have, because you can have contractual protections built into there. And look at your privacy policies too. That's not germane to this particular webinar, but if you're not familiar with privacy and litigation in the US, we also need to talk. And then my final tip, if you're on this list, you're probably going to receive our Denton's US greenwashing guide in your inbox in the coming days. So if you didn't pick up on all of my tips and tricks, they'll be reiterated in there. Thank you, and Annabelle, over to you.
Thanks very much, Michael. Great, so I'm going to be talking to you all about some response strategies that in-house counsel can be using. But firstly, I just wanted to flag that when we're talking about green and social claims, it includes a lot more than just the claims that are made on the product and the packaging themselves and the advertising and marketing content. As Michael's already mentioned, the general reputation of a business would be considered or reviewed in terms of class actions and regulators, as well as things like the logos that goes next to any content, the text and color of the formatting, content that's in your annual reports. So green and social claims can be across your whole website, and it's actually very complex and hard to identify all of the many claims that a business might actually be making. So what can in-house counsel do to ensure that they have a robust global strategy for ensuring that it has a strong compliance management system in place to mitigate against these legal risks? First of all, those claims need to be identified. You need to unpick exactly what claims the company is making and where any risks might lie. This can be done from a jurisdiction perspective, or just globally look at all of the green and social claims that the company is making. And then you need to marry that with the evidence that you've got. Importantly, to protect yourself from any class actions or regulator investigations, you need to have evidence to substantiate any claims you're making. So you need to identify the evidence that you've got and marry that with the claims that you're making and look for any gaps that you might have. Once you've done that, you can do a review of your governance structure, have a look at what policies and procedures you might have in place. And we often do workshops with clients where we discuss with the head of procurement, the marketing team, the legal team, all in one room, what processes and procedures they have to safeguard against any claims that they might be making, not having the sufficient data to back up those claims. And on the back of those workshops, we can produce compliance guidelines for businesses to make sure that they are following the correct procedures and steps, so that they've got the substantiation in place for each of their statements, as well as marketing checklists to assist the marketing team and to help ease the burden on the legal team in reviewing any content that they want to push out. So as a bit of a summary of some of the things that we see as best practice, or some of the steps that companies might be wanting to take to help mitigate against the risk of any greenwashing action brought against them. These are the type of things that we would expect to see, but I do want to flag that it's very important that this is, very much depends on the industry, the company itself, its size, and that sort of thing. So this is just a bit of a guide, but things like compliance guidelines that I've just mentioned, policies and procedures in terms of reviewing any marketing content or phrases that are used in annual reports or on the product packagings themselves. If you're a reseller, you would be looking to have a brand questionnaire, auditing rights in your contracts to give you that protection and that right to maybe go to the manufacturer and actually check that they have that evidence in place themselves. You'd want to allocate someone as point of responsibility, maybe have some training for give some training to your marketing and legal team, as well as having a regular review of these policies.
Great. So we're conscious we've gone through a lot of content so far, and we'd love to get a sense check or a read where everyone is at this point. So the question we'd love to understand is, when it comes to this area, which of the following do you have in place, or maybe you're planning to implement in the next 12 months? So lots of people getting involved already. Quick off the buzzer. So yes, we're seeing some trends already. I'd love to get more people engaged to get a wider sense of what everyone is probably doing at the moment, or maybe planning to focus on over the short to medium term horizon. So do, if you can, just let us know via the poll option. We'll just give it a quick countdown. So let's go 5, 4, 3, 2. Lots of votes coming in. 1. We'll give it 2 seconds for any last minute indicators. Okay, so let's end the poll. Annabelle, I know you're dying to, I would imagine, comment on this one.
Absolutely.
So can see the results now.
Yeah, so that's a really interesting result. Policies and procedures are obviously incredibly important and form the basis of any management system that you would have in place. And checking that those policies and procedures are being implemented effectively is also very important. I would emphasize that actually the evidence bank and the data gathering is equally, if not more important, because that substantiation is what's going to protect your company should a regulator knock on your door, or there start being murmurings from NGOs or any class actions. If you've got that evidence and that substantiation to support your claims, you're in a good position to fend off any legal risk.
Great. So I think we're now going to move over to Jennifer for communications and crisis management, which is such a key part of this area.
Okay, brilliant. Thanks, James. So when we talk about ESG, it's easy to see that this is an area of risk. Obviously, it's also a big area of opportunity for companies. Many companies, probably the vast majority, in fact, are trying to do the right thing when it comes to ESG. They want to communicate their genuine commitments and actions. However, one of the challenges and one of the things that can often go wrong is that there's a disconnectedness in terms of how companies are talking about and communicating on ESG. So sometimes what we see when we talk to businesses is that this whole topic is being dumped on the desk of one of these departments to deal with. So sometimes it might be the general counsel, who is increasingly coming to be seen as almost a sort of social consciousness of the organisation in some cases. They may adopt, often a very sort of risk-based approach for obvious reasons. There are lots of risks in this area. So, they may well think more about what's going to expose us. Perhaps it's better to say nothing at all. On the other hand, if this ends up with investor relations or with the communications team, then the tendency might be to actually say too much and potentially share too much information, and then potentially make claims that can't be backed up with clear evidence. So if there are disconnects between the different functionalities within a company, then often inconsistencies can result from those. So when we're advising businesses, we always start from the premise that there needs to be a really clear top down board driven and approved ESG strategy and a narrative and a story linked to that, which is very interconnected with the business, and that any ESG program needs to be properly embedded and integrated. I think that's one of the key ways that you can protect yourself from greenwashing risk, is by actually doing what it is that you say you're doing. So all of these different teams within a business need to be involved, not for anyone to hold the pen on their own, but because they talk to different audiences. So, there needs to be a joined up story, which is then rolled out to different audiences, depending on, whether you're speaking to a customer, to an employee, to an investor, and so on. So that I think is a really important point to make there. And, if we move on to the next slide, businesses should be concerned about greenwashing. This is a very real risk today, and there's a bit of a concern in calling this section top tips that we're oversimplifying what it is that you need to do. But I do think, having said that there are some very basic rules to consider from a practical perspective when it comes to how you're communicating with your stakeholders, and these tips here really sort of look to what I know from my conversations with different groups, with investors in particular, in fact, a lot of what we're seeing around expectations of companies is coming from that group of investors, but also, the points that have been made earlier by James and by Annabelle, that when it comes to what regulators, competition authorities, advertising standards are looking at, these are sort of some of the areas that, if you sort of think about these, then hopefully you'll avoid falling foul of those organisations also. So I think, first of all, understanding what's important to your stakeholders. We are in an era of ESG fatigue. There's lots and lots of noise out there. So important to be really clear about what actually matters to your stakeholders and talk about those issues rather than trying to be everything to everybody. Be detailed and transparent in terms of how you talk about ESG. So, it's not about making a sweeping statement, but, being really clear about what it is you're actually doing. So, rather than, talking about the importance of diversity to your business as a whole, and sort of setting, kind of sweeping commitments, be very clear about what it is that you're doing, be very clear about your objectives, about how you're performing, about your data, about your progress, and demonstrating that progress is really important. So being really specific about what it is that you're actually doing. You need to make sure that your ESG strategy is your ESG strategy. It's not just, jumping on the bandwagon of what everybody else is doing. It needs to be right for your business, authentic and real. So, really thinking through what ESG means to your business and what it is that you should be doing. Don't try to cover up shortcomings. So nothing goes right all the time, and honesty really is a better policy than trying to paper over the cracks and hoping that nobody will notice. But in case you're thinking that, perhaps it's better not to say anything at all, there is an emerging risk called greenwashing. And greenwashing is the risk of not talking about what you're doing from an ESG perspective at all, for fear of being called out for being over enthusiastic. And, we're starting to see, at least in Europe, we're starting to see concerns being raised about lack of information for fear of being accused of greenwashing. So a new risk coming out of greenwashing. So moving on to the next slide, what can businesses do to prepare should the worst happen and should your business be accused of greenwashing? Well, our teams spend a lot of time working with businesses on crisis planning, and the key to this really is being prepared. So don't talk about if this happens, talk about when. So a lot of what I'm going to talk about on this slide is really to do with what you need to do before you face an issue around greenwashing. So first of all, assessing your reporting, assessing what it is that you're saying to the market, to other stakeholders, to identify where your vulnerabilities might be. So this is, reviewing your financial reports, but also thinking about, what are your key spokespeople saying in the media? What is the conversation that you're having on social media? And that's not just what you're saying, what your people are saying, it's what others are saying about you. So, are you being strategic in what you post, but avoiding oversell? What is the tone of the commentary around your business? What are the key threads? Are there notable messages, themes, trends that are developing? Are there any inaccurate facts that are spreading about your business? So, doing that really in-depth analysis of what the conversation is around you out there. And then based on this, developing appropriate risk mitigation and engagement strategies. So, if necessary, reconsider your messaging if it's not landing in the right way. Horizon scanning is really important. So, how are you positioned in the context of how societal expectations are changing? So societal expectations are evolving very, very quickly. And as we've seen, the regulators are looking to those when they think about whether or not something is counts as greenwashing. So important to stay abreast of how societal expectations are evolving, and we can do this again through techniques such as traditional media analysis, but also really targeted social listening. Important to ensure that the legal team is closely involved in any messaging and communications around ESG. So you need to be really careful that these are accurate, truthful, but also risk conscious. So working together across teams. And then the importance of scenario planning, as I've mentioned, really can't be overestimated. Based on those ESG vulnerability assessments, make sure that you have crisis plans, recommended prepared statements should you be investigated or targeted, and really make sure that all of that is well understood across the organisation, that it's practiced, and that you repeat the whole exercise regularly. So we run crisis simulations for businesses where we go in and we help them to road test what would actually happen if you faced an accusation that, for example, one of your products that is labelled environmentally sustainable is actually discovered to have fake credentials. So, what would you do? How would you manage that? What would you say and to whom? And then we leave behind a crisis playbook, which includes communications principles and practices to follow. And again, this is an area where having a team working alongside you that combines legal and communications expertise is really, really helpful. So now we're going to the final poll question, which is around how prepared your organisation is for a greenwashing-related reputational crisis. I'll be very interested to see the results of this one.
Okay, so lots of people again getting involved. It was great to have views from so many. So hopefully everyone, the poll is still running, I can see. And we do have lots of, so I'm going to end and share results with everybody, and then I think we can go to questions. Great. So Jennifer, did you want it somewhat prepared and not very prepared, are the main thrust of the results from a survey perspective? So I think that's good news from your perspective. Lots of work to be done.
Good stuff. So just to finish off, I'm going to put some questions to the panel and just get some last thoughts. So the first question is, what do you see on the horizon in your respective areas when it comes to managing greenwashing risk? Michael, could I come to you first? What do you see on the horizon?
Sure. On this horizon here in the U.S., I just see more of the same because those factors that I overviewed that drive private litigation, meaning class action litigation, until one or more of those materially change, there's not going to be an incentive. I should say there's not going to be a disincentive for plaintiffs, consumer class action lawyers to not bring these claims. Those same incentives are there for securities litigation. And frankly, a lot of those same incentives are there for regulators when they do exercise their enforcement authorities. They can pursue large civil penalties and that sort of thing. So while we have this alignment of financial incentives and consumer demand for eco-friendly products and practices, and companies frankly trying to meet that demand and being responsible stewards in their industries, they're just going to keep being targets, given that this is an industry, and that's going to continue, an industry within an industry. They're going to continue to see those claims really until that, I mentioned the paths of least resistance point, until there's really a shift in how the law develops favorably to us as defendants defending these claims. When we stack up a number of wins that can be applied to other cases, when it becomes clear to plaintiffs' bar attorneys that it's not going to be an easy win, an easy payout, I'm probably going to be given a similar presentation until that happens.
Good stuff. Good for your business, Michael. Annabelle, how about you? What do you see on the horizon?
I think we're going to see increased regulator action. So we're already seeing in the UK a lot of focus on the fashion and retail industry. I think that's going to increase across areas like food and drink and toiletries, anywhere that's any company selling goods to households generally. But also just globally, I think regulators across the world are going to be under increasing pressure to start acting against companies in line with UK, the Netherlands, Norway. So I think increased regulator action.
Yeah, definitely consistent with what we're seeing. And Jennifer, what about in your area? What do you expect to see?
Yeah, I mean, I think as with Annabelle and Michael, it's clear that these types of accusations and the risk is only going to increase. And, I think from a reputational perspective, really, as soon as the accusation is out there, as soon as it's been said, regardless of whether that progresses to a litigation situation or not, the damage is already done. I think another interesting trend that we've seen is pressure on those who are seen to facilitate greenwashing. So not just the organisations themselves and what they are saying, but others who might be being seen to enable them to greenwash, whether that's auditors, banks, those who set the listing rules. So interestingly, in the UK, we saw Client Earth, a very influential NGO, targeting the FCA, the UK listing authority, for signing off what it considered to be inaccurate climate-related disclosures in the prospectus of a company that was listing. So I think we'll probably see more of that, and that focus coming on lawyers, consultants, perhaps, if they're seen to facilitate greenwashing too. So I think that's sort of that kind of sphere of who might be seen to be responsible for greenwashing will also widen.
Great, thank you. And I was going to ask a final question about sort of final takeaways, but I'm keen that we make sure we picked up questions in the chat box. And there is one from Miri Miller, which is said that I've seen a number of greenwashing claims against companies that embed those trigger words you mentioned earlier. I think this is aimed at you, Michael. Embed those words in their trade names / trademarks. How do you see that being addressed through litigation and/or regulation? Do you have any thoughts on that, Michael?
Oh, absolutely. So in litigation, yes, it's not uncommon for companies to embed those terms in brand names and company names, to trademark variations of them. And in the litigation that I've primarily focused on, consumer litigation, the plaintiffs' lawyers will, for lack of a better expression, shove that in the company's faces, and shove that in the judges and theoretically the jury's faces as further evidence of an intent to greenwash, to create an image that is not actually backed up. Now, having said that, my experience with companies that are taking those kind of steps, that are actually going through the advanced, rigorous process of evaluating whether and how to, for example, trademark a claim, are the types of companies that are thinking about the issues that we've been advising you on this webinar to think about in advance. What can you say? What should you say? How can you say it clearly? Getting legal regulatory compliance functions involved up front, having substantiation to make a claim. So when I am in the position of defending these types of statements in these types of cases, I embrace those companies and brands that have taken those steps, because that usually means that in the process of, for example, applying for a trademark, they've done some advanced homework on whether they can and should say those claims and whether they should back it up. So it's a long way of saying, yes, we do see that interplay. How it shakes out is kind of a case-by-case determination. But I, for my part, I like to see that sort of advanced thinking from our clients.
Great, thank you. Well, I think we're close to the top of the hour, and I'll hand back to Niamh. But before that, I just wanted to say thank you so much for everyone that's attended this webinar. We hope you found this really useful, and thank you so much to all the members of the panel for what I think has been a really fascinating insight.
Thanks, James. So equally, we'd love to hear what you let us know. Did we cover everything you expected? There's lots of activity coming up from a webinar perspective. Please do, I'm not going to go through it in detail, please do get involved. We love seeing you online, share with your teams, and let's continue the conversation on this and lots of other issues around greenwashing and beyond. At any point, you can contact us at cxprogram@dentons.com. Have a lovely rest of day.